Hello, everyone, and thank you for joining me. I'm Jill Bloom with Walls and Ceilings, and welcome to If Walls Could Talk. It's always a great day when I have some time to spend with my good friend, Trent Cotney, partner of Adams and Reese. Trent, great to see you, and thanks for joining me.
Thanks, Jill. Happy to be here.
Well, Trent, you're always busy and you always have lots of presentations that you're doing and things you're talking about. But there's a couple things I'd really love you to share with everybody. First, it sounds like you did a presentation at the National Insulation Association, and they had some great questions for you. What were you talking about? What were your questions, and what would you like to share?
Yeah, so this was at the SEGA Conference, Southeastern Regional affiliate of NIA, and great turnout, great group. Kind of gave an industry update on what I'm seeing in the insulation market and, some legal issues to watch out for there, but had some great questions. And one of the questions was concern about pay up paid clauses, right? Pay up paid clauses for audience members that don't know. Pay up paid clause basically says that I, the prime contractor, don't have to pay you, the sub, until I'm paid by the owner. There's usually some magic language that's required. It's got to say conditioned upon, or it's a condition preceding a precedent to payment, that kind of thing. But it is enforceable in many states. Some states prohibit it. Virginia, for example, is one of the states that prohibit it. They recently enacted a law that says you can't use it. But for those states that have it, it's really tough if you're a sub working on a job, especially commercial work. So if you see one of those clauses, it's important that you look to maybe revise it to allow for payment in a reasonable time, rather than basically betting on the fact that your general contractor is going to get paid by the owner.
Yeah, that sounds painful. What would you say is the percentage of jobs where that actually really messes up a contractor? Is that happen more often than not?
If it is in a state that allows it, you can guarantee that every general contractor of any kind of decent size is going to have that in their contract. When I'm, again, as I only represent the righteous. But when I'm drafting contracts for, contractors downstream for their subs, I make sure to put that in their contracts downstream. So
Yeah.
it is something that if you're in a state that has that, you can expect and anticipate that it's going to be there.
Yeah. Yeah. Good, great advice. It's all about the contracts, as you say.
Right.
Everything in writing.
There you go.
And the other thing we were talking about, Trent, it sounds like we're doing another presentation for the National Women in Roofing in Dallas, and
Yeah.
had all kinds of great questions. What was that?
Yeah.
Please share.
A lot of great group there, great chapter. Obviously National Women in Roofing, tremendous organization. They've been around for more than a decade now and really done some good work in the industry. Get more people involved and get the message out. So the Dallas affiliate is if not the largest, then definitely one of the largest. And over the years, got to know a lot of those people really well. So love the opportunity to be able to speak to them. And we talked about a bunch of different things.
Yeah.
It was interesting. Some of the questions were, what does the insurance and storm market look like? What is the horizon for storm and insurance work? And one of the things I told them was, we've talked about it before, is a lot of the regulations and limitations that you're seeing coming out of Florida are going to be adopted by Texas, Colorado, and North Carolina, and the other major storm markets. So those restrictions include, prohibitions against certain type of advertising, limitations on door knocking, elimination of assignment of benefits, elimination of the ability to get attorney's fees on certain types of claims. So all of this is designed to decrease the amount of insurance claims that are out there. But the one thing that we spoke on that I think some people were stunned about is that at least two insurers in the state of Florida have already obtained permission to exclude hail from coverage altogether. So if you start having insurance companies rolling out with extremely high deductibles or exclusions for hail, that's going to revolutionize and change how storm and insurance contractors go to market. One of the things I suggest, regardless of whether you're walls and ceilings or doing roofing work, is don't make your contract contingent anymore. Don't make it contingent upon insurance. Make it a hybrid model where you look to insurance first, but in the event that insurance doesn't pay, you're going after that homeowner or customer for payment. The reason I'm suggesting that is because I think there's so many changes happening in the insurance market that long term, you're going to have to move closer to a retail strategy. This is sort of a hybrid between retail and insurance.
Wow. Wow. Yeah, that's so interesting. And what I do love about, even though you're meeting with, National Women in Roofing, I love the questions, because like you were just saying, it doesn't matter if you're in if you're on the walls and ceiling side or the roofing side, all these questions really apply to everybody, especially the next one. You mentioned you were talking about reputation management. Was
Yeah,
another
it's,
one of the questions.
this is a big deal. And as, AI and other things have progressed and changed, so has, how you go about tackling reputation management. So typically, what I recommend is always be vigilant, make sure that you have alerts and other things out there that will identify whether or not your company's been named or anything like that so that you can watch and monitor those reviews. Depending on what's done and how it's done, sometimes you can go through the actual, review outlet, whether that's Google or Yelp or, whatever it might be, and seek to have a defamatory comment removed or something that's maybe salacious or whatever it might be. You can also look to potentially take, other websites down. You go into their servers or host, like GoDaddy, for example. I've had, a lot of issues with fake sites being put up. But ultimately, what you want to do is always leave with customer service. Even if you think someone is wrong, try to reach out and see if they're willing to redact or remove a negative review in exchange for additional services, maybe compensation, whatever it is. Just remember, if you engage in this kind of communications, don't threaten. And if you come to a solution, make sure you get it in writing, right? Joe, we're always talking about that. Never give away something for nothing when you've got a disgruntled customer. Get that release, get that something in writing so that you know where you stand in the event that they don't do what they said they were going to do.
Yep, always in writing for sure. And the other thing you had mentioned that you had got some questions on were in OSHA and just movement and what's happening in the future.
Yeah, it's been interesting because there's still some stuff that's percolating out there, right? We've
Yeah.
seen, some additional movement on the heat injury and illness standard, but it is sort of, in stasis right now. It's still going through the rulemaking process. Whether or not that comes to fruition during this administration, I don't know, right? The one thing that we have seen is that there hasn't been a significant amount of rulemaking on other types of rules. There's been some guidance and other things that have come out. I will tell you that from an inspection standpoint, it's business as usual. The rank and file are the same rank and file that we've dealt with for the last, 15, 20, 25 years. It is business as usual when it comes to that. I do think that this is a favorable administration to challenge certain rules and things that might have been taken for granted, between some recent case law that's come out, as well as a favorable administration and, Secretary of Labor and Dave Keeling, the head of OSHA. I really think there's an opportunity to get standards that recognize the complexity of construction, but also ensure the safety of our workers, which is always paramount.
For sure, absolutely. And I
Mhm.
think you said you also had some questions on indemnity.
Yeah. Yeah. So indemnification, look, Joe, there's a lot of things that keep me up at night. Indemnity is one of them. Typically there are indemnification basically means that if I screw something up, I'm going to hold you harmless for it. Right. And there are three different types of indemnity. There's limited form, which means if it's my fault, I own it. Right. There is intermediate indemnity, which is I will agree to indemnify you in whole or in part, right? And if I see that in part, I like to take a little red line and cross that in part out because that means even if you're 1% liable and someone else is 99% liable, you potentially have indemnity obligations. The last one is broad form indemnity, and it means I hold you harmless not only for my bad acts, but your bad acts. Now, recognize, Jill, that in every single state, there are statutes and case law that have very specific requirements. Some states say you can't do broad form. Some states you can't do broad form or intermediate. The reality is that if you are the one providing indemnification, you want to limit it as much as possible. Consult your insurance agent to make sure you have the appropriate insurance coverage to handle that indemnity if it comes. Obviously, if you're looking to push stuff downstream, you want to maximize it. So if you're using subs yourself, you want the maximum amount of indemnification that you can get in your particular state.
Lots of great information there to unpack, Trent, as
Yeah.
always.
Oh, yeah.
And it's always great to catch up with you and hear what you've been talking about, especially the questions. Like we've talked about this before, but it's always great to hear the questions that you're getting because those are usually what's top of mind and what's happening out there.
Well, the reason that's so good, Jill, is not only do we get to talk about it, right, but it allows me to understand what the real issues are. So we can put out content and try to get in front of these issues to protect, our walls and ceilings and roofing contractors that are out there.
Absolutely. Well, if anybody does have any other questions, Trent, how do they find you?
Sure, they can hit me up via email, trent.cotney@arlaw.com, or anywhere social at Trent Cotney.
Sounds great. And thanks again, Trent. If anybody has any questions for us, it's roofingcontractor.com or wconline.com. And we can't wait to see you next time. Thanks again, Trent.
Thank you.